This conference will now be recorded.
So I'd like to welcome everybody to today's webinar on August 21st, 2020. Everything you wanted to know but were afraid to ask about guardianship. And today, my goal is to give you accurate information so we can debunk the myths of what people read or misunderstand. So there's going to be some analogies today to the story of Alice in Wonderland to help us understand the process called guardianship. So the idea of having to petition and become a guardian for a loved one can seem daunting, almost like what Alice felt like when she looked down the rabbit hole and was debating whether or not to follow the rabbit. So we're going to start with something very basic that I think will help everybody understand what's guardianship and when and why would we need to pursue guardianship. So the basis here is that our state wants to make sure that people are protected, their health, their safety, their well-being, and most importantly, their financial affairs. So protection applies to both adults who are incapacitated as well as minors, meaning children that have not yet reached the age of 18. So I'm going to give some examples of adults that might be incapacitated and could need a guardianship. The first would be a situation where a person is physically incapacitated. That could mean they are in a wheelchair due to some medical condition, or perhaps they are paralyzed. It could be that they're not in a wheelchair, but physically they are declining to a point where it is impacting their ability to make good judgments and rational decisions about their own well-being and medical care. Maybe they're neglecting their own care. Maybe they're not properly taking prescriptive medications, or they're not making appointments to see a doctor, or they're not keeping appointments. Those are just a few examples. Now, an adult could be incapacitated because there's cognitive decline. So sometimes the body is in good physical condition, but the mind and the brain are affected by something that is going on. It could be that there is a chemical imbalance. Perhaps somebody has been in an automobile accident and they had an injury to the head. There might be trauma to the brain. Or there could be something else going on that is causing decline in certain areas of brain function. So we refer to that as cognitive decline. Perhaps somebody has become very forgetful. They are not paying their bills, and suddenly FP&L turns off the electricity, or the utility company turns off the water because bills have been ignored and are delinquent, or the mortgage hasn't been paid. Those are a few examples of where perhaps it's an indication that cognitively something is going on and this person is not doing the things they normally would to handle their financial affairs, or even to take care of themselves physically. So you might notice something like their clothes have not been washed and there are stains on the clothing. Or you might look at their fingernails and notice that there's dirt. They're not exercising what we would think are good hygiene habits, or their hair looks disheveled. These are some indications that somebody might be experiencing incapacity. An adult may also be incapacitated as a result of a mental health diagnosis. That might mean, again, there could be a chemical imbalance or something genetically going on, and they might have a diagnosis of severe depression or perhaps schizophrenia or bipolar disorder. And so their perception of reality is very different than what is actually happening around them. So a mental health issue that is not being properly addressed, whether it be through a combination of medication, therapy, nutrition, and exercise, might lead to an adult becoming incapacitated and needing to be protected. For a child, we don't refer to the word incapacity, we just simply say they're a minor, and situations in which a minor might need a guardian appointed could be as a result of a parent being incapacitated. For example, we might have a single parent and the couple is divorced, the other parent has already passed away, and the remaining parent becomes incapacitated. They might be in a car accident. They might have an aneurysm that has burst and left them in an unconscious state of mind. Or parents might have passed away. So in those situations, we need a guardianship, possibly for both protecting the assets that the minor has or is going to receive from the parent, or just to simply make residential decisions, pediatrician medical decisions, as well as decisions as to where the child is going to attend school. So now that we know the type of people that might need a guardianship, why would we pursue a guardianship? Why would we go to court and ask a judge to make us the guardian of somebody that's either a child or an incapacitated adult? The one thing we need to keep in mind is that every adult, when they turn 18, has certain legal rights automatically, whether or not they are capable of exercising those rights. For example, all of us have the right to vote. We have the right to travel and decide where we want to go, how we want to get there. We have the right to determine who we want to socialize with. Where do we want to live? We also have the right to make our own medical and mental health decisions. We have the right to handle our own financial affairs, to pay our bills, to decide maybe I want to take out a loan or a mortgage. I need help to finance a house or the purchase of a car. We have the right to decide if we want to make gifts to anybody, whether they're a friend or a family member. We have the right to apply for government benefits, whether it's to the Social Security Administration, the Veterans Administration, the Medicaid office. And if we've been injured by somebody and we feel that they were responsible, we have the right to sue them in a court of law. And if we have caused an accident, somebody else has the right to sue us in order to recover and be made whole. So because people automatically have these rights as adults, we cannot just simply, without a process, take away these rights. So guardianship is a legal process in the court system by which we ask a court to determine whether somebody lacks capacity to properly exercise either some or all of these legal rights. So now that we understand people that may need guardianship, that everybody who's an adult has certain legal rights, we want to ask ourselves, why guardianship? Why would I want to pursue a guardianship? Well, the most frequent example that I see in my law practice is when we get calls from a family member telling us that there is an adult who they believe is incapacitated. And when this person was mentally competent and aware, they did not go to an attorney to have certain legal documents put in place that would serve as an alternative to a guardianship. For example, the person does not have what we call a durable power of attorney, which is a document that gives permission to a trusted person to make their financial decisions should they become disabled, sick, or incapacitated. It may also be necessary if the individual who's incapacitated does not have a legal document called a designation of healthcare surrogate. Similar to the power of attorney, this is a document that gives permission to a trusted person to make healthcare decisions if we are disabled, sick, or incapacitated. So if these documents do not exist and the adult lacks the necessary awareness and understanding to be able to sign these documents, then our next measure or option is a guardianship, because we cannot simply put a piece of paper in front of an adult and say, sign here. It's going to be okay, just sign. That is not the way we want to make sure somebody understands what they're doing. It's important for people to have the document explained to them and for there to be a conversation to make sure that they're aware of their surroundings, they're aware of who their family members are, and most importantly, that they're aware of what their assets and their income is. So capacity is awareness. It's not the ability to hold a pen in our hand and simply sign our name on a legal document. Another reason why we may need to turn to the court and pursue a guardianship is that there could be legal documents in place, but perhaps somebody is contesting the validity of those documents. So we might need to go to court and seek a guardianship so that the judge can determine, are the legal documents valid? And then a determination as to whether or not guardianship is required. Now, sometimes people believe that there are no documents in place, so they pursue a guardianship. And later on, after they become guardian, they locate documents such as a durable power of attorney or a designation of healthcare surrogate. In that situation, we want to bring this to the attention of the judge as soon as possible. And it might be possible that we can get the judge to close down the guardianship and allow the individual named in the documents to use those documents as a less restrictive alternative to guardianship. Now, for a minor, we might need a guardianship if parents, when they were alive and they had capacity, did not sign a document called a designation of healthcare surrogate for a minor, in which they gave somebody they trusted the ability to make healthcare and residential decisions for their child, or if before they passed away, they did not create a trust for their child so that the trust would receive monies or assets they were leaving to the child. So for example, we might have a grandparent leave assets to a grandchild in their last will and testament, but not think about the possibility that when the grandparent died, the grandchild wouldn't yet be an adult. And as children cannot by law manage and handle assets. So there needs to be a mechanism to protect the inheritance and protect the child. And so in that instance, we may very well need to go to court and have a guardian appointed to oversee the inheritance. So how do we start the process of guardianship? So the process is called an incapacity proceeding, and it's called that because before we can get a guardian appointed, we actually have to prove that certain legal requirements have been met and that a person's legal rights should be removed from them. So we have to establish that the person is incapacitated. And to do this, the courts in Florida have certain procedures in order that we respect the rights of the person who is alleged to be incapacitated, and we refer to the process as providing due process. So the first thing that happens once we file the court papers that are signed by the client is the clerk of court will appoint an attorney from the community in that county to represent the person that is allegedly incapacitated. So our legal system in the United States makes sure that everybody has not just access to the courts, but that they have legal representation. So the role of the court-appointed attorney is to represent the alleged incapacitated person, to meet with them, to understand what might be going on, what could have led to the incapacity, and to make sure that rights are not removed unnecessarily. The second thing that the clerk of court does when the papers are filed is they appoint an examining committee. The examining committee is comprised of 3 professionals. One is usually a licensed medical doctor, and that can also be a neurologist. A second person may tend to be a social worker, and the third person can be a nurse. Or in some counties, the third person is a lay person. Now, their job is to meet with the alleged incapacitated person and using their different professional backgrounds and disciplines to perform an assessment as to how that person looks, how they behave, and how they respond to questions. Each examining committee member is required to complete a report about the assessment process. And at the end of the report, they are asked to make recommendations as to what rights the individual should keep and what rights should be delegated to a guardian. They are also asked to make a recommendation as to whether it should be a full guardianship, meaning all rights are removed, or a partial, what we call a limited guardianship. Those reports are filed in the court and they are sent to the judge to review. The judge will not leave the courthouse to actually meet with the alleged incapacitated person. So having the examining committee go out and also having the court-appointed attorney meet with their client enables the judge to make an informed decision. The third step that the clerk of court will take is they will schedule a hearing for approximately 4 weeks after the initial papers are filed. Now, for some people, this may seem like a very long time to wait, and I would agree. However, both the court-appointed attorney and the examining committee need time to do their job in the due process. So that's why the hearing is set approximately 4 weeks later. Now, a hearing can either be held in front of the judge, or in certain counties, the judges will have the hearings held before what is called a magistrate. And a magistrate, though not yet a judge, has been trained in these procedures to listen to the testimony and take evidence, and then make a recommendation to the judge as to whether a guardianship is appropriate. At the hearing, the burden of proof is on the person that is coming to the court asking for a guardian to be appointed. So that person with their attorney must prove why the person is incapacitated and whether some or all rights, whether they be medical rights or financial rights, should be removed. At the hearing, one of the decisions that must be made by the magistrate and the judge is whether the petition was filed in good faith. Now, this is very important because we want to encourage people to properly use the legal system, and we want to discourage people from thinking that they can file for guardianship just to take over or take advantage of somebody's assets. So the answer to this question will determine whether or not the judge is going to require the person who came to court to pay the legal fees. If the petition was filed in good faith, then the person who petitioned is not responsible for paying the examining committee or the court-appointed attorney. But if it is determined that the petition was filed in bad faith, that there was a hidden agenda of the person, then they can be held personally responsible for the legal fees and the examining committee fees that are involved. Now, let's kind of bring everything into context with what's happening right now in our country due to COVID-19. Our courts closed in mid-March, and so now all hearings are being held through video conference. So we have the parties present by video, their attorneys. The alleged incapacitated person will also attend by video unless their attorney has excused their appearance. And why might they do this? Well, the court-appointed attorney may feel that it will upset the person too much, it would be burdensome, or that there is nothing that their client is going to be able to contribute to the hearing. Otherwise, hearings are all held now by video, and people will be sworn under oath who are going to testify, and any evidence that is going to be presented will have to be filed by the attorney with the court prior to the hearing so that the judge and the magistrate will be able to view it during the hearing. As we're leading up to the hearing, one of the things that needs to be done by the person who wants to be appointed the guardian is they will undergo a background investigation. In Florida, if somebody has been convicted of a felony, they will not be appointed a guardian. And it does not matter whether they are related by blood or marriage to the person who is in need of the guardian. So this is a strict rule that is applied across the board. So there's two aspects to the background investigation process. There is a criminal background investigation and there's a civil background investigation. To initiate the criminal investigation, every potential guardian must submit electronic fingerprints. And these fingerprints are going to be run through the FBI database, as well as through the Florida Department of Law Enforcement database. And the results are sent to the court monitor's office in the courthouse. They will then share those results with the judge, and if anything negative has shown up, the attorney for the petitioner will be notified. From a civil background check, the court monitor's office is going to look to see what this person's credit is like, for example. Do they have a lot of unpaid debt? Have they filed bankruptcy? Now, should those facts exist, that by itself does not mean the person won't be appointed guardian, but it's something that the judge will take into account in making a decision on who can best serve as the guardian. So once we get through the hearing and the evidence has been presented, if the judge or the magistrate feels there's sufficient evidence to demonstrate that this person lacks capacity and they need a guardian to be safe and for their assets to be protected, the court wants to look for the least restrictive alternative. So sometimes that could mean that the individual is going to be allowed to keep certain rights. So we then refer to it as a limited guardianship. Maybe they're going to retain the right to vote. Maybe they'll retain the right to marry and the right to travel, but the other rights would be removed and given to a guardian. Or if the evidence has shown that the person is not capable of exercising any rights or would be very unsafe, they might be taken advantage of by unscrupulous individuals, then we refer to it as a plenary guardianship, meaning it's full, all legal rights have been taken away. At that hearing that we call the incapacity hearing, there are two very important questions that the magistrate and the judge will ask. And the first one is whether the petitioner knows if there are any medical advance directives that exist. So if you remember at the beginning of our conversation, we talked about whether a designation of healthcare surrogate exists. If it does, this is a type of medical advance directive. The judge will ask, is the person who's named as the surrogate alive, and are they willing to make the medical decisions? So it might be that the surrogate will act as to medical decisions, but the judge might appoint a guardian for financial decisions. Or if there is no healthcare surrogate, or the person named as the surrogate has passed away, or they themselves is incapacitated and there's no other surrogate named, then the judge will indicate that in the report to explain why there is a need for a guardian for medical decision making. The second question the judge is going to ask is whether a durable power of attorney exists, because this could serve as a less restrictive alternative to financial guardianship. So if a durable power of attorney exists, the judge will ask similar questions such as whether the person named in the document to serve is alive, are they competent, are they willing to serve? And the judge has to make a decision whether the judge will allow that document to continue or not. Now, sometimes there are valid reasons why a durable power of attorney should not be allowed to continue. And one, for example, could be that the person who's named in that document is not properly carrying out their responsibilities. Maybe they're abusing their power. Maybe they have misappropriated assets from the incapacitated person. So there is a legal procedure to ask the court to suspend the authority under a durable power of attorney, and that will be addressed at the hearing. Depending on the evidence presented, the judge will either decide to allow the power of attorney to continue, or the judge will suspend the power of attorney and give a guardian the authority to make all the financial decisions. So one of the questions I'm asked often is, what are the safeguards in a guardianship? Or people will say, you know, over the years, I've read articles in various newspapers that talk about how guardians, whether they're family member guardians or a professional guardian, that they've acted outside the scope of their duties, that they've somehow gotten their hands on the assets of the incapacitated person. So let's talk about what Florida has in place for safeguards. The first thing that Florida does when a guardian is appointed is the judge signs an order naming a particular financial institution to be the depository, meaning all the assets and income have to go into that account, and the bank account is restricted. That means that neither the guardian nor the attorney who represents the guardian can go into the bank accounts without first having a court order. So this is the first and foremost very important safeguard. The second safeguard is that in addition to the restricted account, the judge could also require a guardian to post a bond. A bond is a type of insurance policy that ensures that the guardian will act properly and faithfully. And if they don't, then the insurance company is responsible for replacing any misappropriated assets. So this is the second way that the ward, the incapacitated person, is protected. Additionally, within 60 days after a guardian is appointed, they are required to file with the court what are called initial reports. And this informs the judge what the person's income is and their assets that are going to be marshaled into the restricted account. If you've been appointed guardian of person to make medical decisions, residential decisions, healthcare decisions, then you have to prepare what we call the initial plan. And this is a plan for the next 12 months that tells the judge where will the ward live, who will their medical providers be, how often will they see those providers, what kind of therapies will they need, what type of health insurance do they have or government benefits. And so it creates a plan as to how this person is going to be cared for. If you've been appointed guardian of property, meaning you're going to oversee the finances, then you prepare a report called the initial inventory. And this takes a snapshot photograph of the income and assets on the day the guardian is appointed. Each year, on the anniversary date that the guardian's been appointed, the guardian is going to prepare an annual report. So the judge and all the court employees are continuously looking over the shoulder of the guardian to make sure the guardian is making proper decisions for the ward. If you're guardian of the person, you're going to create a new annual plan, and it's going to be updated from the last plan that was filed. If you're guardian of the property, you're now going to prepare an accounting that tells the judge from the last period of time, going 12 months, how were the assets handled? What was purchased? What was paid? If there were assets such as stocks or bonds, did they go up in value or did they decline in value? So these are very important safeguards that help to protect the incapacitated person. In addition, the courthouses have what is called the court monitor's office. Now, this is the office that does the background investigation on all prospective guardians that apply, but they can also, at the request of a judge, look into how is a guardian managing the finances and how is the guardian taking care of the person. So the court monitor can do an audit, a financial audit. They can also go out to visit the ward and do a report to the judge. And depending on what that report says, the judge may require a hearing where the guardian has to be present to answer questions the judge has about how they're carrying out their duties. Now in Florida, we don't have just one type of guardianship, we have several. So it's important when working with a guardianship attorney for them to determine, based upon the facts and the circumstances, what type of a guardianship is appropriate for that individual. The first kind of guardianship is called voluntary. So if you think about the word voluntary, means that this is being done with somebody's knowledge and their consent. They're realizing that perhaps they're starting to have some physical challenges that affect their ability to handle their financial affairs. So they're asking the court to appoint a guardian for them. Voluntary guardianship is only over finances. It is not over the person. It does not give the guardian the ability to make medical or healthcare or residential decisions. So why might somebody want a voluntary guardianship? I'll give you an example. Perhaps somebody is getting on in years, their spouse has passed, they never had children, and they have some distant relatives, but they don't necessarily have a close relationship, And so they might be hesitant about trusting somebody in the family to oversee their financial matters. So in that situation, they might want a voluntary guardianship knowing that the court is going to be overseeing and supervising all the actions that the guardian takes. And there are all those safeguards in place, such as the inventory and the annual reports, as well as the restricted account, that gives that person that sense of confidence that the actions of the guardian are going to be watched closely. Now, in order to initiate a voluntary guardianship, we need a letter from the person's physician saying that the doctor met with the patient and the patient understands the guardianship and they're willing to ask the court to have a guardian appointed for them. So in the proceeding, we actually do not have an examining committee that goes out because we have the letter from the person's physician, but the other due process steps are followed. Now, with the voluntary guardianship, the individual could decide at any time that they'd like to stop it, and so they have the right to ask the court to terminate their voluntary guardianship. Most guardianships are going to continue as long as the person is alive, unless the person somehow recovers capacity. So let's talk next about the involuntary type of guardianship. As the word sounds, an involuntary guardianship is usually done without the knowledge of the individual because they are incapacitated. And that could be that their incapacity is so severe, or perhaps they're in denial of their incapacity. It could also mean that the person had a tragic car accident and they are affected cognitively. And so perhaps with proper therapy and time, they might years later have some legal rights restored to them. We've seen that happen. It depends on each person. More likely with a younger person who has health on their side, they might be able of having rights restored. I've also seen where it's possible that people with certain mental health diagnoses who are compliant with their medication, their therapy and treatment, over time may have certain rights restored, and if the judge is satisfied that they are properly taking care of themselves and properly handling their finances, a judge could decide to terminate the guardianship and give that person back their legal rights. The third type of guardianship in Florida we call emergency temporary guardianship. And as the name indicates, we have to prove that there is an emergency present. There are only two types of things that are considered true emergencies in the eyes of the court. And the first one is that we have to be able to prove that the individual is in imminent harm. There is imminent danger to their safety and their well-being from a physical point of view. If we can't satisfy that requirement, the second basis for seeking an emergency temporary guardianship would be that somebody is being financially exploited. And so here's where we need to have evidence and hopefully the cooperation and assistance of the financial institution to help us demonstrate that somebody is taking advantage of this individual and they are slowly removing assets from this person's control. Now, an emergency guardianship is temporary in nature because the purpose is to allow a guardian to stabilize the situation and see whether at the end of 90 days is this person going to be able to safely and properly make their own medical or financial decisions. If more than 90 days is needed, we can petition the court and present evidence and testimony as to why more time is required. Sometimes the emergency guardianship will actually lead into the involuntary guardianship, which is more permanent in nature. Now we have two types of people that can be appointed a guardian. The first is a family member can be appointed guardian, and generally speaking, the courts do prefer that families step up and agree to take on the responsibility for a family member that is incapacitated. It's important to always think about the possibility that the person appointed as the guardian is human, and they themselves could become sick or disabled at any time, or they can even die unexpectedly. So it's important from the very beginning to think about also naming what is called a standby guardian. So the word standby kind of means that we have an alternate guardian who applies and goes through the background investigation process and has been pre-approved and is ready to serve should anything happen to the primary appointed guardian. Guardians in Florida are entitled under the law to be compensated for the time that they are spending to oversee the care and the finances of the incapacitated person. What the courts require is that the guardian, just like their attorney, maintain typed records of what they're doing, when they do it, and how much time is spent. Those records will then be submitted to the judge for the judge's review. The judge will read all the entries to first determine whether the task performed was necessary for the ward, whether it benefited the ward, and whether the time spent was reasonable. The judge will then make a ruling and sign an order that determines what is the compensation to the guardian. Now that order will then be certified by the clerk as an official court document, and it will be presented to the bank where the accounts are restricted, and the bank will then release that money to the guardian. Without the order, no monies are released. The second type of guardian that could be appointed, we refer to as a professional guardian, because these are people that have undergone certain training, and this is their job, this is their career as a professional guardian. They're also entitled to compensation. It may be at a different or a higher rate than a family member guardian, but family member guardians may also be entitled to a higher rate if they can demonstrate that they hold a certain degree or certification that contributes and benefits the ward. Now, you might be asking yourselves, why would a judge want to appoint a professional guardian and not a family member? Didn't I hear Stephanie say that the judges prefer that family come forward and take the responsibility? And that's still true. However, if there is something in the family member's background that would prevent the judge from appointing them, that could be a reason to look to the appointment of a professional guardian. Another reason is that if two different family members both apply to be guardian and they object to the other being appointed, or there's fighting going on within the family, a judge does have the discretion to appoint somebody who's neutral, who the judge feels is certainly going to follow the rules of guardianship law in Florida. So that can be another basis why a judge would appoint a professional guardian rather than a family member. So after listening to this webinar, you might say, well, I'd really like to avoid a guardianship. How could I do that? Is that even possible? So it is possible under certain circumstances. And the one most important factor that you need to know is that the way we can avoid a guardianship is when we have a person who is still mentally aware. mentally competent, and is willing to put into place what we call an incapacity plan. And the plan will include several documents that creates a management plan for when this person might become incapacitated in the future. So we would want that plan to include a durable power of attorney giving permission to a trusted person to handle the finances. And the nice thing about the durable power of attorney is that the person you name to handle things for you is not being made an owner of your assets. They're simply being given permission and what we call a fiduciary responsibility to handle your financial affairs, to take care of you. The plan might also include a revocable trust where your assets are put into this trust to make it easier to manage, and you would name a successor trustee to step in when you become incapacitated. So that would also be a less restrictive alternative to going to court and needing a guardianship. Now, those two things help with financial management, but let's not forget that we have this other side to our life, which is the personal. Who's going to make my medical decisions? Who's going to decide my care and treatment plan? Who's going to decide where I live? All of that is important. So our plan needs to include a designation of healthcare surrogate, an advocate who will step into our shoes when we can't speak or we can't communicate and make the best decisions for us. It might also include medical advance directives like a living will that expresses our preferences for end-of-life care and treatment. It might also include a declaration that says we'd like to donate organs for transplantation or medical research and study. Or it could include a do not resuscitate order. Another very important tool that can help certain people with avoiding a guardianship is what we call a declaration of pre-need guardian. This is a legal document where you get to say, if I need a guardianship or somebody files for a guardianship, this is who I want the judge to appoint. So you can appoint in the document the person you want to be your guardian of person and who you want to be guardian of property. And it doesn't necessarily need to be the same person. You might feel that one person has the skill set or the experience to do the best job to handle your financial affairs, and perhaps somebody else is better suited to make your day-to-day medical and living decisions. Under the law, this document creates a presumption that the person you name should be appointed absent the background investigation showing that they have a felony conviction. So for some individuals who might have family members where they anticipate they're going to argue or fight, this document might be very important because it will cut through that, and the judge will, because of the presumption, be required to appoint the person named in the document. Over the years, I've had the pleasure and privilege of working with individuals in the LGBT community. And some of those individuals' families have never accepted their lifestyle choices. And so for those clients, we offer the declaration of pre-need guardian to assure them that the judge will appoint their partner or their boyfriend or girlfriend rather than a family member who might attempt to swoop in and take over when there's been no relationship between the two. So if you can't avoid a guardianship, if you find yourself in a position where a friend or a loved one is already incapacitated, it's very important that you work with an experienced guardianship attorney. It will make a world of difference in how you go through this experience. So one of the most important things is you want to work with an attorney who knows that county probate court requirements. Although Florida guardianship law is the same and applies to all counties within the state, sometimes certain counties will have their own additional requirements or nuances. So it's important that, number one, the attorney not dabble in guardianship. You want to be asking them, how often do they take a guardianship case? How many guardianship cases are they handling currently? But you also want to ask, do you have the experience to work in the county where I need to file the guardianship? You want to be assured that the attorney can handle things timely. You should be having your hearing 4 weeks after the initial papers are filed. It should not take longer than that. And you want the process to be efficient and cost-effective for you. So do ask the attorney whether they employ paralegals or legal assistants to help them where certain tasks can be delegated to those paraprofessionals and billed to you at a lower hourly rate than the attorney's hourly rate. And you want to see, how does that attorney relate to you during the consultation, because communication is so important. You know, you don't need the attorney just at the beginning of the guardianship, but Florida law requires that a guardian continue to be represented by an attorney all the way until the guardianship closes, because there can be new requirements either under the law or in the county that the judge requires. And it's the job of the attorney to keep the client informed, to teach the client how to meet the requirements, how to do their annual reports and get them filed on time. So you want an attorney who's going to educate you on an ongoing basis and keep you informed throughout the life of the guardianship, which could span for many years. So I hope that you have found this topic interesting. And at this point, I'd like to open it up for questions. You are welcome to either unmute your microphone or please feel free to use the chat box, and I'll be happy to read the question out loud. Well, if there are no questions, I want to thank everybody for joining me today and remind you that this will be recorded and we'll put it up on the website. So you're welcome to visit the website, www.fl-elderlaw.com, and please register to watch the webinar again. And please look at the wonderful library we have of all past webinars that are available to watch. I hope you'll consider joining me next Friday on August 28th for our last webinar of the month, and we're going to be asking and answering the top 10 elder law questions. And definitely don't forget that on the website there is a complimentary gift certificate as well as a free document checklist to help you prepare for your consultation. Shay, do you have a question you'd like to ask?
I actually, you answered the question that I already had. I was the one I did have was a power of attorney versus a guardianship, but I think in the last series I'm pretty clear on the answer there. So it's been very helpful. I'm also a caregiver for my mom. I have some of the advanced directives. The one thing I don't have is a healthcare surrogate, so I definitely need to put that on my personal list. But certainly understanding the position of a guardian, and then also it just, honestly, this makes me realize the importance of every single person. It's not a kind of human versus human. It's like, wow, if all of this goes into the care of one person, every life really does matter. So it's refreshing to remember that. So thank you.
Oh, thank you, Shay, for sharing with all of us. And although some of us may be at a point where our loved one can't do these documents because they lack the capacity. I hope that you'll walk away from today's webinar thinking about how can I use this in my own life so that I can do it differently for my family.
For sure.
Lori, did you have a question?
No, I don't. You answered many of my questions. You definitely have got me thinking, and it's something I probably need to move forward to in the very near future for my sister. I don't. No, thank you. Thank you very much. Very
Well, you're
interesting.
welcome. And thank you for joining today. I want to wish everybody a wonderful weekend, a very safe and healthy one. And I look forward to you joining me in the future. Cassandra, did you have a question?
I didn't. I just wanted to tell you how informative I thought this was as well, and I appreciate the seminar.
Thank you so much. And please, everybody, we are in a challenging time. Please make the time to practice self-care. Get out and exercise, eat well, meditate, get good rest at night, and take care of yourselves. Thank you.
Thank you.